Call the meeting to order. Everyone present is seated. Need a motion for the minutes.
Move to approve. Move to approve. Second.
Motion by McGuire, second by Ward. Any additions, deletions, or corrections to the minutes? Seeing none, all those in favor?
Aye.
Aye.
Opposed? The motion carries. Need a motion for the consent agenda?
Mr. Chair?
Yes.
I'd like to remove the first item, the child support payments from the consent agenda.
Okay, 2021-117 is removed from the consent calendar. Any
Move.
discussion on the balance of the consent calendar?
Move to approve.
Second.
A motion by McGuire, second by Gray. Any discussion? All those in favor?
Aye.
Opposed? The motion carries. Is this a loan thing on your removal?
I don't know.
Okay. We'll start with item 7, the Board of Dental Examiners.
Mr. Chairman, this is an emergency rule from the Board of Dental Examiners. What this rule does is currently by rule, only 40% of continuing education units for dentists can be done by online, by webinars. Given that there right now is very limited access to such in-person seminars, to live seminars, the board is put forth this emergency rule that would, for 180 days, allow 100% online live webinars to be used for credits. The concern is that dentists are not going to be able to meet their requirements to renew their licenses, and it's going to reduce the number of dentists available, plus cause economic harm to those dentists. The committee, there was a similar rule by one of the other boards a few months ago.
Any discussion? Is there anybody here from the dental?
I don't believe so. They had asked staff if it was necessary. Oh, there is? I'm sorry.
Good morning, I'm Tina Kelly. I'm here to represent the Board of Dental Examiners. I'm the program specialist with OPLC, and I'd be glad to answer any questions you might have.
Can we expect this situation to be corrected in the near future?
It's anticipated this will be the only time this emergency rule will be needed. At the present time, they're not doing live courses, but they will be going back to those. So I anticipate that this will rectify itself.
Okay, thank you. Yes. Yes.
I just have a quick question. I don't know if Ms. Kelly knows, but approximately dentists are affected by this year.
This would probably, and I don't know the number of dentists there are licensed in the state, but it is my anticipation that changing this rule or not changing this rule would affect all the dentists because they have to get a certain number through live courses.
Thank you.
Okay. Next, we're going to take up item 9, Department of Agriculture.
Mr. Chairman, depending whether you're looking at the agenda that's online or the one that had been sent out by email, there is an error in items 9 and 10. And says response not yet received, response due by April 26. That is not the case. We have received the objection response just in the last day or two. That is applicable, however, to item 9. We have not yet received the objection response for 2021-104. But Christina can talk to you about OR 2021-107 and the objection response.
Okay, so 104 goes to the next meeting.
Yes.
That's item 9. And go right
So,
ahead.
Objection response 2021-107 is on the licensure of architects. And the committee staff no longer have any comments. The agency did a great job of eliminating the unclear comments with the forms from previously. I just have a note to GELCAR because originally there was an inadequate fiscal impact statement. This was because in between the IP and the FP, the fees for these licenses changed, and there wasn't an updated fiscal impact statement. There is now, and that is attached in your packet. So everything has been, or all concerns of committee staff have been eliminated.
Motion.
Move to approve.
Second.
Motion by Lang, second by Gray. Any discussion? All those in favor?
Aye.
Opposed? Okay. Board of Education. Item 103, school year and distance education.
103, committee staff have no comments. I think it's on the agenda because we were anticipating public testimony.
One section of the rule deals with remote education. There's a general prohibition with some limited exceptions, and we didn't know if that would cause any public testimony or not. Otherwise, it would have been on the consent item.
Is there anybody present who wishes to speak to this? Yes? No? I see. Okay. So
Move to approve.
Second.
motion by McGuire, second by Lang. Any discussion? All those in favor?
Aye.
Opposed? Motion carries. Item 102, education freedom accounts.
Mr. Chairman, before we start to discuss this rule, we need to take a preliminary procedural vote. When our office received the conditional approval request, it was less than the 7-day required by statute. In that instance, the department can request the committee to still take up the conditional approval response. And I have to say it was by no fault of the department that the conditional approval was late. They received our final proposal comments quite late and simply did not have the time to fashion a conditional approval response before the 7-day limit passed.
Okay, we need a motion to accept the rule.
Second.
Accepted by Gray, second by McGuire. Any discussion? All those in favor?
Aye.
Aye.
Opposed? Whoever's speaking for the department. Identify yourselves.
Frank Edelblue, Commissioner of Education. Chris Bond, attorney for the Department of Education.
Okay. Mike?
Thank you, Mr. Chairman. I'll run through the issues as quickly as I can. If you're looking at the text online, you first have a 10-page letter from the board and
Can you put his microphone on, please?
Turn it off. No,
I
Okay.
wasn't the one talking, though.
Edith, just turn the machine off.
Okay. Is this better? The first 10 pages of the proposal here is a letter from the commissioner discussing comments by OLS staff, by Jerry Zellen, and by the ACLU. And the first 6.5 pages of the text is just struck through. Substantive comments by committee staff start on page 9. And I have to admit that I'm winging this a little bit. It was Kim's rule. She is out sick today, so I'm picking it up. The first comment is at the top of page 9. We don't have a specific concern with the language of this paragraph. It just, we felt, was the appropriate place to put the comment below, which was a concern about the broad language in 194 F2 Roman 2O. F2 lists the items that can be educational expenses that can be approved by the scholarship organization. The paragraph O is a catch-all that says any other educational expense approved by the scholarship organization. We're concerned that a lack of criteria here would allow carte blanche to the scholarship organization to approve or disapprove other items. The department's position is that, this is legislative intent. The statute authorizes the scholarship organization to do this, but we're concerned that the scholarship organization is actually a vendor for the state and is spending state money without adequate direction. There is no criteria about what can be covered and what cannot. I presume the committee would like us to take these one at a time and allow the agency to respond.
Yes.
Great, thank you for that. So one clarification. So as the comment was summarized, there's an indication that there is no criteria for the scholarship organization to be able to adjudicate whether or not a expense through the Education Freedom Account is eligible or not. And we would assert that there is criteria in the statute as it was crafted by the legislature, and that comes across in a couple of different ways. First, there is an enumerated list of expenses. It's A through O, O being the last item. And if you see in our response, we've quoted some case law on this, that O can't be taken out of the context of being part of a list and say, like, when it says any other eligible expenses, it doesn't mean they can just, or any other expenses, they can just go out and spend it on anything they want. They have to be in the context of that list. And then if you go and you look at, the reference in 194 F22, it is enumerated in there what are types of eligible expenses. What are we supposed to be spending? It says to provide an education for an eligible student in the core knowledge domains that include science, mathematics, language, government, history, health, reading, writing, spelling, history of the constitutions of New Hampshire and the United States, and exposure to appreciation of the arts and music. So for example, if a particular student said, well, I want to spend money on how to become an airline pilot, well, I don't see that fitting into these categories here. So we think that there is appropriate constraining language for the scholarship organization to be able to have criteria to apply this as we go forward. And then the final point that I will make is that the department also has a programmatic monitoring. So we will be reviewing expenses at the back end of this and auditing to make sure that they are eligible expenses. So I believe that there are plenty of constraints in place, and that the legislature, by creating that O category, is acknowledging that it's not possible to enumerate every expense that some student may use eligibly on educational expenses. So there's this catch-all rather than us trying to enumerate it. And I don't believe it was the legislature's intent for an agency to narrow down what those expenses might be by us coming up with our own determination of what other expenses might look like.
Questions from the committee?
So is the middle ground, adding to the sentence, some of the items that the commissioner suggested in there and giving other expenses consistent with, and then adding, you know, at least a brief or a reference to the language?
Well, so we would assert that that broader language is already part of it. I mean, again, it's got a long list of expenses to begin with. It starts at A and goes all the way through A. So it's defining a lot of different types of expenses that are eligible. So us trying to add to a list that goes from A, you know, through O already, I don't think is going to add clarity. What we really need to understand is that they have to be eligible education expenses, but I'm not sure. And then is your question that we should put a negation? Here's what's not allowed?
If I may, Mr. Chair.
Hello.
You read a statement that the education expenses should be consistent with.
Yeah.
And then you read the statement.
Yep,
okay?
I said I read the
And
law.
What I'm suggesting is that instead of just say other expenses, that say other expenses consistent with, and then put that statement that you read either in, you know, the words in, or put a reference to it in, and therefore you get what you want, he gets what he wants, and we've crafted that win-win that we're always seeking, right?
Yeah. So, I mean, you know, certainly the jail clerk can do what they want if they think that's necessary. I think that that's already clear in the statute and in the law. We would basically, what would be happening is we would take RSA 192 F2(2) and restate the exact same language into RSA 192 F2(2)(0). So in other words, like, so it's already in its context that here's the introductory, here's the broad categories of expenses, and then you've got enumerated lists of expenses. And so we would just take that paragraph and reiterate the exact same paragraph over again. So I'm not sure that it adds clarity per se.
Representative McGuire.
Thank you. Mr. Chair, I don't think this is the right place to put it in any case, because this paragraph I is dealing with the Parent and Education Server Provider Advisory Commission, which is responsible for appeals, for denials and other expenses. So as long as there is anything that is not specifically enumerated, this paragraph says there is a advisory commission set up in statute which deals with appeals and whether other expenses are appropriate. So I think we don't need to say here that they have to be in accordance with anything.
Thank you,
Senator
Mr.
Whitney.
Chair. Thank you, Mr. Chair. Perhaps we could do it a little different. We could, you know, instead of enumerating everything in the rule, we could just say something like, you know, that the expenses are limited to those areas specifically in the statute, and then cite the statute. Would you object to that?
I don't have an objection to that, because again, you all can do as you see fit, but I think that that's already in the statute. It says that these are the only things that you can do with it, and so we're reiterating
No,
that.
that's not my question. So the reference would be, you know, that the expenses are limited to those in the statute. So it's a limitation to what's in what you're just saying, what's listed in the statute.
Yeah, so I think we already have that language in there that we're saying you can only spend it on these eligible expenses. So we are saying that. I think that
So you wouldn't object that putting that into the rule then?
I think it's already in the rule.
I disagree.
Okay.
It's not.
It's not in this location, it may be somewhere else, Senator.
Mike.
I'm not sure that Senator Whitley's suggestion would clarify the problem, because if you just require compliance with the statute, well, O in the statute has that catch-all that's very broad. I mean, the purpose of rules is to clarify and implement the statute. So that catch-all in the statute hopefully would be fleshed out in the rule. I think Senator Gray had a pretty good suggestion. I'm not sure exactly where it would go in the rules, but to say, for the catch-all in the rule, to say consistent with the items listed in A above.
Perhaps we should look at, on page 11, qualifying EFA expenses, where it limits some of the items, and it goes on to say you know, D under there, which is at the top of page 12, says a scholarship organization shall publish on its website a policy for pre-approval of qualifying educational expenses consistent with F2O in this section, so that they would list out, once people identify other qualifying expenses, they list them and say, this is not specifically enumerated, but it's appropriate. So I think I agree with the commissioner that it's already there.
So just reflecting that, that's what I'm saying is like, I feel like we've already pulled that into here and say you can only do the things that are enumerated.
I also just wanted to point out, OLS staff noted that the state is in contractual privity with the scholarship organization. So the department does have oversight through its contract, and agencies don't manage their contracts through administrative rules. So the scholarship organization is in constant contact with the department over issues like this, and it is the department's understanding that the list is limited, that the catch-all. I mean, the department's understanding is that as the commissioner said, the legislature believed that it was impossible to enumerate every conceivable educational expense that could be consistent with the core provisions that are set forth, and the department would have the same problem in limiting. There's a essential case-by-case nature of looking at a lot of these, and the department thinks it would be contrary to the legislative intent to somehow limit that by constraining it. But we do have this contractual privity and the relationship with the scholarship organization, so that the department's understanding here will effectively be the way the scholarship organization manages this process.
Senator Whitman.
Thank you, Mr. Chair. So I understand that, there's that contractual relationship with the department and the scholarship organization, but wouldn't you agree that, the legislature has a very important role, and JALCA has a very important role in understanding how public funds are going to be spent? And I'm particularly uncomfortable with such a broad catch-all that we would have, that we're writing a blank check, essentially. Wouldn't you agree that the legislature has an important role in managing public funds?
I would emphasize that the legislature has the premier role in managing those funds, and our role is to administer the laws that you've given us. So there is that category O that says other educational expenses, because the legislature, it appears, determined that there's this long list of A through O. O being, we don't know what else might come up, but it has to fit into the categories, the broad categories of eligible expenses that we've defined in this law. And so what I'm trying to avoid is the agency taking over the responsibility that the legislature acknowledges that there's this catch-all required to administer this program, because all of a sudden then I'm sitting in the seat of a legislator trying to enumerate what those other categories might be, when the legislature clearly had the intent of trying to enumerate as much as they could come up with and then adding another category. So I would say that the actions of the agency are deferring to the supremacy of the legislature in trying to decide this.
Follow up? Thank you. So, right, so we have this catch-all. As the agency, can you provide some information about what the department would consider applicable to those, that catch-all? What expenses would fit into that?
Sure. So anything that fits in the categories A through, up to O, elemental P, would qualify, right? And the legislature has enumerated all of those. But there are today parents who are applying for expenses, and those are being rejected by the scholarship organization. Those rejections have the ability to go on appeal to this commission that would oversee those. So there is a mechanism for relooking at those. But some of the types of expenses that may be excluded, if somebody came along and said, well, I would like to buy furniture for my home so that my child can do their homework more comfortably, and therefore they might even make the assertion that my child could be more effective at their homework. That wouldn't, I've got my list of A through O, that would not fit through A through M. N. And so then it may, so a parent may try to fit it into category O, but then we would look to the statute which says, is this, you know, science, math, language? And we would adjudicate and say, like, that's not an eligible expense because it doesn't fit into the categories that the legislature has given us, and so it would be rejected. And it hasn't been that difficult to determine. You know, I start with my list. If I don't see it on the list and it falls into O, I go to my broader categories. Does it fit into these broad categories that the legislature has given us? If it does not, it's not an eligible expense.
Yeah, so I don't think you answered my question because
Okay,
you
I'm
have that
trying.
enumerated list
Yes.
and then you have a catch-all, which
Yeah.
is very broad. So you have indicated some areas that would be excluded, right? But you haven't said, what are those areas that aren't enumerated that might be caught up in the catch-all? What I'm concerned is the breadth and the scope of the catch-all. And I think that's exactly what the JALCAR staff is telling us. And so that's the area that I haven't heard. You've said number of times enumerated. That's clear. We're talking about the catch-all here. And in the rule, I believe that we need more clarity on what would be included and what would not be included in that very, very broad catch-all.
Yeah, so then I would just, again, reiterate, we are trying not to sit and usurp in any way the legislative power, which was very clear in terms of their enumeration. And so for the agency to then step in and make adjudications and determine, you know, that beyond the fact that you've given us further guidance for O, which is science, math, language, and et cetera, right? So that is the frame through which we can look at anything that wants to pass through O has to meet that criteria, and that's how we understand that legislation has been crafted.
Senator Gray.
I don't agree with some of the things that Senator Whitley has said. Our job here in JALCAR is to take what the legislature did, and I supported that bill, I voted for that bill, and put the rules together, okay? We put that catch-all in there, okay? And if we want to slightly give them some more guidance in this rule, similar to what I had said before, is in the proper place, say consistent with the other things that are in the bill, that makes sense. But to try and define it down to a very fine point does not make sense. And it is, in my opinion, not consistent with what we're supposed to do in the Rules Committee. Thank you.
Representative McGuire.
Thank you. I'd like to ask the commissioner whether or not he knows whether the scholarship organization has published any qualifying expenses consistent with paragraph O, which they're required to do by this rule.
Yes, I don't believe that has been published at this point in time, so I don't know the answer to that.
But I think.
But we will be publishing that as
Yeah,
it comes due.
I think that by publishing what qualifying expenses have been considered to fall under that catch-all, we will be able to determine if that's too broad or not broad enough. Because right now we don't have the data, the program has just barely started. And so I think that by showing that what types of things qualify for that section O, we will be able to answer Senator Whitley's question and narrow it in legislation if necessary.
Senator Whitley.
Thank you. So, thank you for that clarification, but my concern, and I think it's the concern of the JALCAR staff, is that, you know, letting the scholarship organization determine that scope would be sort of an impermissible delegation of authority by the Department of Education. Wouldn't you agree?
Actually, the law specifically says that the scholarship organization is determining whether those are eligible expenses. You did not delegate that power to us. We do have oversight responsibility, so we can go in and do programmatic monitoring. But in fact, we're trying to follow the law as closely as possible with this.
Mr. Chair. Representative Lang.
Representative Lang.
Thank you. I'm just trying to gather it all back in. So the way I read this section D on here is that it took section O, which was basically, we didn't want to create an exhaustive list. We said, here's a list, and then if there's anything else that you find that falls in because we didn't think of it, it goes under category O. Is that am I getting that first section right?
This is how we understand the legislature having passed it to us.
Thank you. Follow up, Mr. Chair.
follow-up.
So, and then what you've done is taking that direction from the legislature that says here's our we have a non-exhaustive list here and gave you the catch-all, is the scholarship organization will think of the things that we didn't think of, and with the number of parents we have out there that may come up with an innovative idea, it allows you to be able to take that innovative idea, decide whether it falls within the scholarship program, decide whether it's an educational benefit to the child, and if it is, it can be added under the category of O. It'll then be published to the website, so any other parent who want to think about that same thing will also be able to see, oh, that's an allowed expense, I can do that. Is that, and then that list will ultimately grow so parents will be clear what things that the legislature didn't agree with or didn't think of and put into the list that are eligible, and also what's not, right? They can choose if it's not on the list, they can still apply and maybe add it or not. Is that
Yeah,
the way you're anticipating it's going to flow?
I do, and the only constraining factor I have is just because a parent brings something to us under O doesn't mean that it's another eligible expense. That eligibility adjudication takes place when I go back to 194 F3 3D1, which is science, math, and stuff like that, right? So if they bring us something that doesn't fit into these categories that you've given to us, then we would adjudicate that as uneligible.
One last follow-up, Mr. Chair. And then lastly, I would anticipate that you're reviewing as part of your contract management all those things that have been approved, and if you see something you disagree with, you can challenge that with the scholarship organization, or if a legislator sees something on that list that disagrees with, we can put a bill in and deal with that, again, adding LMNOP, another item on the list, and exclude something if we think it's inappropriate. Is that how we see this slowly rolling out and working?
Correct, and as well, then parents also have a valve relief. If they don't believe it's correct, then they have this commission to be able to go and have that evaluated and adjudicated as well, so.
Thank you very much.
Go ahead, Mike.
Next item is on page 10. Kim had a large comment here. I've read the department's response. I have to agree with them regarding FERPA and much of what this says, but I have great concern with the intro language to G, saying the scholarship organization shall have access to confidential student information. That doesn't say how. The department has indicated that that is going to be requested on an application form that's created by the scholarship organization. But as this is worded, there's nothing to prevent the scholarship organization from going to a public school and saying, we want this student's records.
So happy to respond to that. So we have a myriad of other laws that restrict the ability of both LEAs as well as the SEA to disclose information, even with regulatory authority for the scholarship organization to, if in fact that's what you believe, that they would be asking for this confidential student information, the body that controls that information doesn't have authority to turn it over.
That's right, but as the rule is worded, an attempt could be made. It also would seem to indicate that scholarship organization could try to compel the parent to provide this information.
Well, when the department noted in its response that the scholarship organization will have access to confidential information from the parent, it was simply trying to articulate that when an application is received, the simple biographical data of the applicant, the name, the date of birth, the address, that's all information that would be considered confidential information if a school held it under FERPA. So just as a matter of course, if someone wants to fill out their child's name, put it on a piece of paper and give it to the scholarship organization, that's information that if a school had it, they would have to treat as a FERPA record. That's what we're trying to capture. We weren't trying to give any authority to the scholarship organization to ask for anything other than what was is necessary for their application to enroll a child.
Yeah. I certainly understand and am not trying to suggest that
Eligibility for to participate in the program. By granting them the ability to do that, it does not then grant them the ability to go anywhere they want and seek confidential information from participants in the program. And we do have the ability to influence the application and would not allow an application with parents to go forward that would be collecting superfluous or unnecessary information needed for a simple adjudication of eligibility into the program.
Next item.
Okay. On the next page, page 10, paragraph I, again, we're dealing with other educational expenses approved by the scholarship organization. Kim's comment raises a concern about the issue raised by the ACLU and Attorney Zellen regarding this being so broad that religious instruction might fall under this. And I know that we disagree with the department, but we feel that any allowing of paying for religious instruction by the state would violate the state and federal constitutions. I know that's going to be discussed further, so.
Yeah, so, and I would like to allow Attorney Bond to do this, but it falls back to the conversation relative to O. The rule and the law are quite clear that of what is an allowable expense, what is not an allowable expense. So just as religious instruction, as the jail court attorney has pointed out, would be ineligible, it would be ineligible because it would be non-constitutional, right? And so we don't enumerate everything in this rule that would be non-constitutional. There are other expenses that would be not allowed, and so not only could you not, in this catch-all of O, wrap up religious instruction, because that would become ineligible, you would also not be able to wrap up, instruction for, I think we had mentioned, a student to become, an airline pilot, right? Because that doesn't fit into the category of O. And then I'd like Attorney Bond to weigh in really on some of the legal aspects relative to the constitutionality.
Thank you. So I just wanted to clarify with the OLS comment that that they know they disagree with the department about the application of funds for religious instruction. I don't think there actually is a disagreement. So I reviewed the ACLU's letter that they sent to the committee yesterday, or at least the department received it yesterday. And I think we're a lot closer than that letter indicates. So the department agrees that it would be impermissible to spend the funds on religious instruction. We do agree with that point. Where we disagree is this issue with the catch-all language. So I'd refer the committee again to our letter of February 15th, page 6, where we list the case law, numerous, of course, cases from the New Hampshire Supreme Court where when there's a list with broad language, there's a common rule of general statutory construction that those other instances must be comparable to the specific examples in the list. So because of that, because there's nothing that implies religious instruction in that list, we don't believe that religious instruction is implied. Nevertheless, even if someone were to read the statute that way, it would be clearly unconstitutional in our view. So we would, in our contractual relationship with the vendor in this program, the scholarship organization, they certainly understand that that's our understanding, that that's not a permissible use of these funds. And as the commissioner said, it goes without saying that the Constitution is part of the law of the land. It doesn't need to be, that particular constitutional provision need not be specified here and to the exclusion of others. And also, because we have this list, if we with the broad catch-all that's supposed to be read in the way that we believe is supposed to be read in the way we've described in our letter, if we start enumerating items that specifically funds can't be used for, our concern is that other things that the funds clearly can't be used for will, by implication, be acceptable, and we think that will be confusing for members of the public. So we agree that use of religious funds, use of funds for religious instruction would be unconstitutional, and we think it is such an obvious point that it need not be articulated in the rule to the exclusion of other things that would also be impermissible. And then there's other factors too. The department in navigating this, we have to be mindful of the constitutional requirements under both the New Hampshire and the state and the federal constitutions. And under the federal constitution, there's both an establishment clause and a free exercise clause that we have to balance those to spell out one part of it, which this would be like an establishment clause problem that we'd be addressing in the rule, to do that and not also weigh in on free exercise issues that may come up in the adjudications, it just seems inappropriate to the department to have essentially a treatise on constitutional law in the rules when
So it is true, we know, and correct me if I'm wrong, funds are going to religious schools, correct? Right. And so those schools, okay, they are not constitutional scholars. I'm a lawyer. I don't know the law in every single area. If you agree that use is unconstitutional, then why wouldn't you put that in the rule? I guess I'm not understanding the objection, because it's such a clear violation of the Constitution, right? Right? So it's not in the statute. They can't go to the statute. I don't understand the objection to actually putting that in the rule, to provide clear guidance to our taxpayers, to provide clear guidance to the organizations that are receiving this money that this is not permissible. You know, the money is going to religious schools. How do I know as a taxpayer that they're not going to use that money for religious instruction? How do I know that?
Yeah, so as a taxpayer, I would hope that you would know the U.S. Constitution, and you would know that that would be a prohibited activity and therefore would be
Right.
unallowed. But just to your first point, we believe that by including one exclusion will confuse the law, because by enumerating what you're not allowed to spend it on, by default then, parents might say, well, they didn't call out training to be an airline pilot, therefore that must be an allowable expense, right? And so we go back to the law and the statute, which clearly enumerates and says, here's what you can spend it on, as opposed to trying to enumerate all the things you can't spend it on. And so in that affirmative argument, we provide clarity to all of our constituents who are going to have to apply this. Does it fit into one of these categories on the list? If so, then you're all set and you're good to go. And so we think that picking one item that would be disallowed, and quite frankly, an item that's disallowed and fairly ubiquitously understood is, through the constitutional activities that have taken place, that we create confusion for those same families rather than saying, here's what you affirmatively can adopt.
I would just agree that it's ubiquitously understood by the public.
Attorney Morrill.
and
I don't think this requires an exhaustive list or a treatise on what cannot be included. I mean, if you look at not just O in 194 F2, but all of 194 F2 A through O, you can look at things that it says curricular, instructional materials, programs, and we know that the large majority of the funds, not the funds, but the educational providers are religious schools. So reading that list and not being a lawyer, there's no reason that they wouldn't think that they could use the funds towards educational instruction. It would be a very simple fix, and I don't think it's going to open Pandora's box to, well, you didn't say this, so we can do it.
So if I might just respond to that, and the other thing that you have to consider is the application of that too, because these funds are prohibited from being used for religious instruction. So I have many of my public schools today who offer world religion classes, right? And they're studying Hinduism and Buddhism and Christianity and Judaism. And so is that to be considered religious instruction because they have looked at that? No. And so and I think we would all readily agree on that. And so again, we are very clear in terms of what's enumerated, in terms of what's permissible, and religious instruction is prohibited, and that's prohibited by the Constitution. So that's how we see that.
Representative Ruler.
Thank you. Well, I happen to agree with the two people sitting on either side of me. I do not think that there is a problem being very clear when there is an issue, even here in this room, that is religious in nature. We can make it, because we all are wordsmiths here, so that it is very clear that religious instruction is prohibited. Now, we can define instruction if you'd like, but I agree that we need to have something put in here because I'm a lawyer and I don't know what that is. So I don't think it's as clear, in all due respect, that you think it is.
Well, Senator Whitley asked for a clarification of whether funds are going to religious schools right now. It would be unconstitutional if if the department were to have taken this law and said, well, we aren't going to let any of these funds go to religious schools. That itself would be unconstitutional. So the constitutional issues here are fairly complex. And the case law that the ACLU relied on in their letter, the Carson case, that's currently in front of the Supreme Court. This, has the potential to be a somewhat changing landscape. And the issues are complex enough that it's not, in the department's view, it's not simple to simply make a categorical constitutional explanation in there, given the case-by-case nature of these expenditures. Like, for example, the commissioner was leaning into world religion classes that maybe teach about a religion, which would not constitute religious instruction. As we've talked about with the necessity of the catch-all that the legislature decided was needed to implement this, there could be circumstances that come before the scholarship committee or the scholarship organization that straddle these lines, these free exercise and establishment clause lines that are still in some cases emerging and sometimes very complicated. You get cases like Locke versus Davey and the Carson case and the Espinoza case, and given that the department is clear with the scholarship organization that funds cannot be used for religious instruction, we think it's unnecessarily redundant to include that language in here. And if we were to include it, it could cause confusion in the other direction. It could cause people to think, well, I can't use this fund for at a religious institution, and that would have its own constitutional ramifications. So we just think there's the potential to create more confusion.
And I guess I would just add one more thing to that, is that we have not mitigated by not including that language in this law, the ACLU or anyone else's opportunity if they believe that, for example, a religious school that's receiving funds from this is violating the Constitution by using these funds for, religious instruction. They have the ability to pursue that constitutional claim against that entity. So we, to Attorney Bond's point, this is as wordsmithy as we can be. It's not a clear-cut thing, and it is a dynamic landscape. And so we have to be careful that we don't set ourselves up to create more confusion.
Representative McGuire.
Yes, thank you. I'd like to move to approve this rule with the request that the department work with the legislature regarding the legislative issues that have been noted, and also the large number of bills in process. And also that the department report to the legislature in more detail on the issue of religious instruction. Because unlike Representative Roulard, I don't think we can today give you some language that you could insert into the rule.
I'll second that motion, and I do have something to say.
Representative Lang to speak to the motion.
Thank you. Just to speak to the religious aspect, I agree. I think for me, you're in a catch-22. I think if you put down something about religious instruction, then people are going to automatically assume you can't go to a religious school without understanding what that law particularly means when you use that phrase, religious instruction. So I think you're in a really tough spot to try to define that, but I probably need to make a best guess effort and try to do something like that. I just think we're confusing the idea of religious schools with religious instruction, and those are getting conflated together, and we allow the use for religious schools. We don't allow the use for religious instruction, and trying to define that's a great try. But I agree that the rule should be adopted as it's written now, and you should work with the legislature to see if there's something we can do to clarify that in the future.
Okay, we have a motion to conditionally approve the discussion. Representative Tucker.
Thank you. I served 9 years on the Wellesley, Massachusetts School Board. My children most of the time attended that public school. So I am very familiar with the difficulties of coming up with how to deal with this whole topic. And in Wellesley, they had a 2-year course, social studies course, which I called The Roots of Western Civilization. And it had some other bland name. And we skipped, that we went from Greece and Rome, Egypt, the ancient civilizations, right through the Dark Ages. And then we skipped the Reformation and the Renaissance, and they picked up at the French Revolution, because the town was primarily Christian, but many were Roman Catholic, many were not. And so this whole topic of study versus instruction, I think really does need to be worked on, because it affects what is included in the curriculum. Those children who were left out 1,000 years of Western civilization were not as educated as they should have been. So I think I'm happy to support your motion if, when you repeat it, can make sure that it includes a definition or instruction or work on that. I would be happy to support it.
Senator Whitley.
Thank you, Mr. Chair. I certainly cannot support that motion. I think that, JALCAR has an obligation in reviewing these rules to, I think, importantly, make sure that we don't violate the public's trust by allowing a program with so many questions to be implemented, particularly when it comes to our scarce and precious taxpayer dollars. The committee can, looking at the potential objections in RSA 541A 13-4, there are 4 bases for objection, and I think we have heard ample testimony from what we've received from the ACLU, from Drummond Woodsum, from a whole host of other folks, from the JALCAR staff. I believe that the JALCAR staff take an impartial look at every rule, and I respect them deeply, and they have pointed out to us a whole host of concerns. And so I think there are 4 bases for an objection for this rule. And I think, of course, we talk about this a lot in JALCAR, regardless of your policy position on the actual program, we're done with that. But we have an obligation, right, to look at this rule, make sure that it complies, right, that's not in, that it doesn't violate public interest, that it's not contrary to the intent of the legislature, that it's beyond the scope of the agency. And on that latter point, beyond the authority of the scope of the agency, we heard from JALCAR staff, right, that there is not adequate criteria for the scholarship organization to adjudicate where the expense is eligible. I mean, I think this raises a significant question about the breadth and scope of the scholarship's role and authority to manage public funds, and that the delegation of authority to the scholarship organization is very problematic. And then I think the not adding a simple sentence into the rule that funds received by a school under this program shall not be used for religious instruction, a very simple sentence to clarify how public funds are going to be used, to show the public that we are doing our due diligence to not violate the Constitution. That is a simple fix. And, without that, there's no way that I could support an approval. Thank you.
Diane.
Thank you, Mr. Chair. I basically agree with Representative Rouillard and Senator Whitley. I don't feel that I can support this at this time. I think it still needs work. Thank you.
We still have okay. Mike, can you tell us what you have for a motion?
Approval with recommendation that the agency work with the legislature to resolve issues and to work on the outstanding legislation. I'm not sure if I captured that entirely or.
There was also the caveat that they report to us on how they implement the constitutional requirement to not fund religious instruction.
Okay.
Okay, we'll do a roll call vote. No. And I will call the roll. Representative Rouillard. No. Senator Whitley.
No.
Senator Ward.
Yes.
Senator Gray.
Yes.
Chair votes yes. Representative McGuire.
Yes.
Representative Schuett,
No.
Representative Lang,
Yes.
and Representative Tucker. Is that no? Is that? Yes. The motion passes 6-3. And we have the item removed from the consent calendar.
This is 2021-117.
Yes.
It is regarding disbursement of child support payments. Committee staff have no comments.
Yes, I pulled this for consent because when I read the cover letter, it says that the provision is explicitly detailed in federal laws. The department elected to remove this provision from the rule as it would prevent the department from having the ability to act on an immediate federal law or regulation change or waiver. I have no objection to them implementing federal laws, but we are constitutionally forbidden from accepting a change, a federal rule without explicit vote of an elected body. So therefore, I am strongly opposed to this rule.
Good morning. Allison Zinno, Administrator of the Administrative Rules Unit for the Department of Health and Human Services. I apologize, the program experts are not here. We did not expect this to be pulled off the consent calendar. However, I was able to speak with someone in the unit, and if we add back in the federal regulation that explicitly allows the department to hold this monies, would that satisfy?
Yes, that way we
Okay.
would be voting on an explicit rule and
Sure.
not leaving it open for CMS or whomever it is that writes this rule to change it without our approval.
Absolutely.
Which is what we don't allow, which we do not have the authority to do.
So my suggestion then would be to add back in an I, and then it would read something of the sorts: intercepted federal tax refunds made to satisfy a non-4A debt that are associated with a joint tax return shall be held in accordance with 42 USC 664 A3B.
We need a date. We need a specific version of that rule in order to approve it.
Mike?
I would have to say that depends. If they are compelled to comply with the CFR, like DES for a lot of things, then a date is not needed. If they are choosing to comply with the CFR on their own, then yes, a date is needed.
The department is required to abide by that, and our rule actually stated that the department was required to hold for 6 months, but the federal regulation had changed, and it's not to exceed 6 months. The unit then opted to just try to remove that from their rule altogether. That way, it would just default to the federal regulation. However, I have authority to allow to put that back into the rule.
Mr. Chairman. But notwithstanding what I said, if Representative McGuire would like that language in there, then that could be part of her motion.
I would like to have it explicit and not leave it hanging, because whether we're required to follow federal regulations or not, they're not, that's totally unconstitutional.
Allison, could you send us that exact language, please?
Yes.
So that would be a conditional approval, including that language.
Correct. So you've heard the motion. Any discussion from the committee? Seeing none, all those in favor?
Aye.
Aye.
Opposed? The motion carries.
I'm sorry, who made the motion and seconded?
I think I'll second it, but I think Carol made the motion. So we'll try that again. I'll make the motion, Mr. Chair, that we conditionally approve with the language as provided by the agency entered into the rule.
Motion by Lang, second by Gray. Can we restate the motion?
So that was a motion to conditionally approve by Lang to include the language from the agency, and a second by Gray.
You've heard the motion again. All those in favor?
Aye.
Opposed? The motion carries. Is that all our business today?
If you could hang on for a moment, there are a couple things I'd like to bring up under other business.
Okay, we'll cancel the continue meeting.
Okay. For the committee members, on Tuesday, staff met with the chair and the vice chair. We do that every month before the GELCAR meeting to go over the agenda. One of the items we discussed is a concern that over the last 2 years, certainly since COVID started, there has been almost a 50% reduction in rulemaking. That was probably understandable for a while, but it seems to be continuing. And the chair and vice chair expressed a concern, and we have just late yesterday gotten a report from IT indicating what rules are expiring from 21 through 23. The reason being is in the fall of 2011, the law changed to make rules go from 8 years to 10 years. Subsequent to that, there was a lot of rulemaking over the next couple of years to get 10-year rules in place. And a lot of those are going to be expiring this year and next year. And the agencies do not seem to be picking up to take care of that. So we are going to send out a letter after it's reviewed by the chair and vice chair to let people know about that. The other thing I probably shouldn't have to mention, maybe I don't, but I will mention, you've obviously all known that committee staff at every meeting is wearing face masks. I just want to assure everybody that is not a political situation. All three of the staff members, staff lawyers, have chronic medical conditions, and it would make it a very serious situation if we got a virus.
The committee appreciates that. Any other items?
No, sir.
Go ahead, Edith.
So maybe we ought to be thinking as a committee, it's embarrassing for me as an alternate to be the one recommending it, but some kind of extensions for certain agencies that are falling behind on getting things renewed.
There's process in place.
Because
Yeah.
what I understand sitting on Ways and Means, we're hearing about bills where apparently rules have not been able to keep up quickly with changing situations. And that, I think, comes first. And the one I'm thinking of particularly has to do with allocations of monies received from opioid adjudications and settlements. And it is spoken of as, money is sitting that could be used, but the rules haven't been worked out. And that's come up on a couple of others. Offhand, I can't think of what they were, but
Okay.
as someone who's even associated as an alternate, I don't like hearing this. I think that new materials always should come before extensions.
Yeah.
So it's just,
Well, all the rules have, unless there had been a final objection, have the value of a law. They're presumed legal and valid, and you must comply. Regardless of whether it's a brand-new rule or one that has been in place for 10 years and now the agency wants to extend it, if those rules go out of effect, it's the same, whether it's a new rule or an old rule. You can no longer enforce those rules. And we do have mechanisms in 541A to allow agencies to take some variance, like adopting an interim rule for 6 months because an agency's rule is about to expire. You can start a rule even before a statute goes into effect. If you know there's going to be a new law, as long as the rule does not go into effect before the law. So there are some measures in place.
Representative McGuire.
Yes, thank you. I hate to drag this out, but the rules are valid for 10 years and then they expire. And we have seen so many cases where the agency comes in and says, oh God, our rules expired 2 years ago and we haven't done anything on it. What I believe the staff memo is intended to do is to say, here's your rules that are going to expire shortly. If you need to change them, then start rulemaking. If you think they're pretty good already, then just renew them as is. And I think that that's what we need to do, is have them think about the fact that their rules are expiring, because if they don't, they're going to end up with expired rules that they can't enforce.
Yes, and the reason for us running that report was specifically to do that, to let some of these agencies know this is happening. One of our problems is that our database doesn't allow us to kind of pull this information easily and to keep track of it, and that is something that we're moving forward with IT to fix that problem in the future. So in the future, we'll be able to kind of ping an agency maybe a year out of an expiration and let them know. So hopefully that will eventually be resolved, but for now, we're doing it manually.
Okay. With that, the meeting is adjourned.
All right.
Do I hear Ways and Means is meeting on Thursday?
What's that?
Did I hear Ways and Means is meeting on Thursday?
Oh, I have to look. I think I did see a notice come through. I'm assuming it's going to be an exec session there, because we've heard all the public hearings, right? Oh, well, we might have, I know we wouldn't have made notice for the bills we passed yesterday, so.